Toronto Estates litigator Charles Ticker says a unique case out of New Brunswick establishes that a gift will be voided if the beneficiary will use it for an illegal purpose. Well, Charles, can you give us some background into this case?
Yes, the case involves the estate of a Mr. McCorkle who left the residue of his estate to a group in the United States called the National Alliance, which is a well-known neo-Nazi white supremacist group in the United States. It also had activities in Canada. The gift was challenged by Mr. McCorkle's sister, and she argued that the gift was contrary to public policy, and the judge on the hearing of the original application agreed with her and ruled that the gift was invalid. He ruled that the National Alliance was carrying out activities that were not only contrary to Canadian public policy, but contrary to the criminal code. Their activities were illegal and criminal, and on that basis ruled the gift invalid. The case was appealed to the New Brunswick Court of Appeal, who just came out with very brief reasons, basically just accepting the application judge's reasoning, and upheld his decision and ruled that the gift was invalid.
I understand it was a sizable gift. I
understand that the estate was about $250,000, including a coin collection, some neo-Nazi artifacts, a skull, but yes, about $250,000.
What's unique about this case?
Well, I think what's unique about the case is that the will on its face did not contain any neo-Nazi language or anything about I want this gift to be used to further neo-Nazi ideology or white supremacy. But basically the court accepted evidence from intervening groups, the Southern Poverty Law Center and some other groups, and got evidence on the activities and the nature and the motivations of this group. And so what's unique is that while the gift on its face was not to be used for an illegal purpose, there was no question that the recipient of the gift was going to use the money for an illegal purpose, and that's what the court relied on to find it contrary to public policy. So had it been a situation where the will on its face said this is for an illegal purpose, that would be pretty straightforward. This case was unique in that it was silent and it just named the group.
How far can this drill down, though, like Confederate flags and drugs and terrorist groups?
Well, that's an interesting question. I think the McCorkle case is pretty unique. However, one could argue, I guess, if a testator leaves money to a beneficiary who is, let's say, a known drug dealer, and someone comes forward and says, well, they're going to use that money to buy drugs or sell drugs and break the law, I guess someone could argue that they should receive the gift as well. But I think what's different is that this was a group that was, its constitution and its website made very clear what its purpose was, and its sole reason for being was to spread this hatred.
It seems that there's been some action lately in estate litigation. Do you agree?
Well, there's no question that with the demographics, we're seeing, of course, many more cases being litigated in the estates field, and therefore we're getting more decisions, and judges, I think, are starting to, not saying become more interventionist, but clearly there is more cases now coming before the courts where the courts will, in the proper set of facts, become a little more active in terms of overriding a will, as opposed to using the traditional methods of challenging a will. We have a case now that's pending before the Ontario Court of Appeal called Spence, and it'll be variant. In that case, a gift was set aside because the court ruled that the testator cut out his other daughter, who was challenging the will, because she had a child by someone outside her race with a white father. The testator was black, and there was evidence that that was his reasoning, even though there was nothing in the will. That case is under appeal, so it'll be very interesting to see what the Court of Appeal has to say about it. In the Spence case, a reference was made to McCorkle, so it'll be interesting to see how the courts sort of deal with a case that deals with a private family matter as opposed to a gift to a public entity that's a known entity that runs contrary to public policy.
Interesting days in estate law. Thank you very much.
Thank you.